Alright, so this is just We the People News. Alright, this video is without prejudice and or without recourse. Okay, I'm not an attorney. I'm not going to give legal advice. I'll give you my opinion only. Do not take it as legal advice because I'm not an attorney. Do you know shit? Alright, so never look just straight forward. Always look around you, be able to protect yourself by any means necessary. That means, you got to challenge these people. Okay, military courts is not Article 3, which constitutionally speaking, that's what we had to have. Alright? However, the court systems itself, the judicial system itself, created their own guidelines. Alright? And these attorneys, bar members, came in there and helped take away our rights. Okay? To profit them. Okay? However, they did sign an oath of office of upholding the Constitution of state and federal, and yet, when you walk in that courtroom, they're telling you do not have Constitution. Sit and think about that, y'all. They're going by codes and statutes and this and this and this, right? It's bypass laws, which is what they call bylaws. Okay? They make you led to believe that ordinance applied to you when American jurisprudence specifically says as a member of a corporation. McDonald's, it applies to McDonald's. It does not apply to you. A resident is a renter. Okay? So they're using these bypass things to really just convict you. Sit and think about it, right? But because of our ignorance and because of our hearsay and not doing research of our own, we are actually, in fact, dooming ourselves, people. By tacit agreement or staying in silence or acquiescence of our ignorance. Okay? Why does it take 2 years to do a lawsuit? It's because you got to exhaust particular orders that they created that's bypassed the Constitution, and you must go into a certain level in order to get your Constitution. So think about that. Your constitutional remedy. Well, that's delay of justice, y'all. Justice delayed, justice denied, violation of due process. Okay? Just saying. We got to watch out for these people, okay? These military courts are not judges. Excuse me. They're not judges. But we are led to believe, and we tacitly agreed that they are judges. But here we go.
Thanks for joining this episode.
And this video is going to show a couple of things they're talking about, but when you overall the realm of the scope, they're also talking about family courts. It's in the same category, okay? Your traffic tickets are in the same category, okay? All these are bylaws. They're bypassing the state law and or the state constitution and federal constitution. This is how they are taking and confiscating your rights, right? By your tacit agreement, staying in silent acquiescence, because you must go by hearsay of attorneys saying, well, you got to do this, you got to do this, you got to do this. There's a process that they created to violate you.
Episode of the number 86 lecture series, where we discuss administrative law, including the history of the administrative state and modern debates about its powers. Today's episode features Professor Gary Lawson, a William Fairfield Warren Distinguished Professor at Boston University School of Law. He has published 9 editions of an administrative law casebook and authored or co-authored a constitutional law casebook, 5 books on constitutional and legal theory and history, and nearly 100 articles. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
We're going to discuss a fairly controversial issue, the legitimacy of agency adjudication. Professor Lawson, what are your thoughts on how to approach this?
is there a constitutional problem with those non-Article 3, non-judge executive officers doing things that look like what judges do? That, I believe, is the single most difficult, long-lived, unresolved, possibly unresolvable question in all of American constitutional law. The reason why that one is so difficult.
Let's stop right there again. It's not difficult, people. We just got to know it, understand it, and stand on the 10th Amendment. Right? Powers vested in the state or the people. That's the or there. Or the people. We do not have to ask for the state permission. We don't have to ask the federal government's permission. We just got to recognize we have the power as well.
Goes to the heart of the whole scheme of separation of powers. The way separation of powers works is the Constitution vests distinct kinds of governmental powers, legislative, executive, judicial, in distinct institutions, Congress, the President, the courts. What the Constitution does not do is define what counts as legislative power, what counts as executive power, what counts as judicial power. It just assumes that most of the time people will know it when they see it. And often that's true, particularly when you're distinguishing legislative power from executive power. It's harder to do that with the judicial power because it wasn't until the middle of the 18th century, just literally a few decades before the Constitution was ratified, that the judicial power became recognized as a distinct power of government. For most of English legal history, what we now call the judicial power was part of the executive power. Just was. The judge.
Correction, y'all. The executive branch, the judicial branch, was actually created for between the people and the king. Okay? Later, evil kings confiscated the judge and started throwing judges in jail. And the grand juries, or juries. There's certain of them that stood up for their rights and this, that, here, and there. However, it didn't stop them from confiscating. And now, we created this country here to bypass all that because we do no longer have a king, right? But the judges and the attorneys are giving themselves the kingship powers. Think about it.
Judges were agents of the king. So the whole notion of the judicial power as something distinct from the executive power is a very new thing at the time of the Constitution. So it's not like there was an enormous body of law or doctrine or prior understandings that would draw the lines between executive and judicial power. So we don't have a lot to go on there. As a result, we have spent 2.25 centuries.
You know what the problem is? They're not following the Constitution. If there's no administration courts in the Constitution, then it should not and cannot exist. Constitutionally speaking, people. Just saying.
Trying to figure out a way to draw that line. Nobody, to my knowledge, has succeeded in doing it. The answer may ultimately lie in something that shows up 3 years after the Constitution is ratified, and that is some language in the Fifth Amendment talking about how you're not supposed to deprive people of life, liberty, or property without due process of law. If due process of law requires the participation of an actual honest-to-goodness Article 3 judge, then the answer may be that administrative adjudication that deprives people of life, liberty, or property would be problematic. Most administrative adjudication doesn't do any of those things. Most administrative adjudication deals with how the government is going to hand out benefits, hand out Social Security, hand out other forms of welfare. And if those decisions don't deprive people of life, liberty, or property because you don't have any right to have it in the first place, then it wouldn't be a problem to have all of that done by administrative agencies.
Explain that, people. How did our property become such a deal, right? Why do we have to fight to not pay taxes on something that's a right to have without having to go to the federal courts? And the federal courts even kind of go in there and say, because we all agreed, tacit agreed, that we own property taxes. We waived our rights. So therefore you do not have a right to own property. You waived it. People, by tacit agreement, stand in silence or acquiescence.
But that's all very speculative. This, as I said, is maybe the most complicated question in all of American constitutional law.
Let's talk more about the difference between Article 3 courts and administrative law courts. Apart from their purpose, do they operate the same way? What does it mean to be called a judge?
Article 3 of the Constitution vests the judicial power in the federal courts. Other parts of the Constitution define certain attributes of those federal courts. The two most important are they have tenure during good behavior, sometimes mistakenly called life tenure. It's tenure during good behavior. They can be impeached and removed for misbehavior. And they also have guarantees against...
Listen to that. They can be impeached. Why is Congress not impeaching these judges when they're not staying within the guidelines of the Constitution, people? Because they're benefiting Congress, ATF, all these other agencies that Congress is not holding their responsibility. They're saying, well, we have the power to create, but you guys can do what you want to do. We're going to stay outside of here. Y'all, every single time it's a voting time, get rid of them. Put a new one in there. If you're a Republican, replace that Republican with another Republican. If you're a Democrat, replace another Democrat with another Democrat. All right? Quit letting these people stay in there for years and make a lifetime benefit out of it. Remember, it's a privilege for them to be a Congress member. It's a privilege for a president. It's a privilege for judges. It's privilege, privilege, privilege. It's not a right, y'all. And yet, their privilege is overriding your rights. And since you are the boss, they flipped it on you. And then you're going by hearsay that they are authority. No, you're authority. You are their boss. And you go, they need to start watching out what? Their job that they can lose by you, the people.
Diminishment in salary while in office. Congress doesn't like the way the federal courts are deciding cases, can't cut their salaries just to punish them for it. So there are certain baked-in features that federal courts have to have. There is an enormous volume of adjudicatory decision-making that happens before people who aren't Article 3 courts, who don't have either of those or both of those constitutional protections. Those include territorial courts, courts in federally held territory, the military justice system, and a great deal of activity by administrative agencies that involves deciding sometimes who gets what benefits and sometimes who gets $1 million a day fines. So there are plenty of people who act like judges, look like judges. Sometimes we even call them judges, territorial judges, military judges, administrative law judges. But from a constitutional standpoint, they aren't judges. What are they allowed to do? What can't they do? The short answer is nobody the hell knows. This is one of the most unsettled.
It really is not that hard, people. That nobody really knows? No. Even if you have these people that's not judges judging you, they still are restraint to the Constitution, but they are so determined to go by the bylaws, codes and statutes, rules, regulations, and all that. We just heard about that on the video, that the judge had to go against his nature of being a rule follower. We also seen these officers going against the law and following policies. This is where we're all at. Why? Because we have too many people claiming that they are the authorities instead of making claims that they are in fact are the authorities, and you're going to stand on the 10th Amendment and say, hey, enough is enough. This country is also a common law country. All right? Common law, everything's to do with trespass, right? Officer shoots you in the back, he just trespassed upon on you, right? He caused harm, damage, and loss. All right? Why is it taking 2 years? Because you had to fight these non-judges all the way up to the judges, and then you are going to be settling outside of court between here and there. So that way it's not on record, y'all. Everybody wants to say, well, we got to see case law, case law, case law. All these judges can't even think on their own. They're going to have to go by precedent. They have to go by other judges' opinions. They cannot think on their own. They're going by past experiences of their judges because, well, they can't think on their own. Right? They can't read the Constitution and actually literally figure out the intent of the Constitution because they're going to go by hearsay by other freaking judges. People. Just saying.
Long unsettled questions in all of constitutional law. It was unsettled 225 years ago. It's even more unsettled today. It's probably uncontroversial that agencies can adjudicate, can apply law to particular facts when they're doling out benefits. That's been accepted for...
Cannot apply law. Cannot apply law. Let that sink in, people.
Very long time. The more interesting question is whether you can have agency officials doling out fines and penalties, depriving people, in the language of the Fifth Amendment, of life, liberty, or property. Are they doing it with due process of law simply because they hold lots of hearings, put on robes, and act like judges? Or do they actually have to be, honest to goodness, Article 3 judges to perform them? Modern doctrine.
Think about that, y'all. Sit and think about that.
Says, to a large extent, the limits of which are unsettled, that they can do that. In particular, there are two cases decided in the middle of the 1980s that make it very clear that agency officials can adjudicate even the kinds of claims, ordinary contract actions, that normally you would think of would be the stuff of courts. But, says the Supreme Court, they can't do too much of that. If they do too much of that, we've got a problem.
See, and that's another problem with these judges, right? They're leaving things open. Every time there's a case, like the Texas over here with the 18-year-olds be able to bear arms, right? But they gave an opening for the states to do what they can do, right? But the issue is infringement is still an infringement. Shall not infringe. It still shall not be infringed. I mean, but yet judges are giving openings. They're creating bypass constitution. They're creating bypass laws. One of them is, I said over and over and over, Terry versus Ohio. Right? That was a bypass of the Constitution to violate your rights that you can stand on the Fourth Amendment. Oh, you're detained. Well, that's arrest. But they used the trickery of words for years and years and years. Everybody believed detained and arrest was two different things. But no, they're one and the same. There's Supreme Court saying they're one and the same. There's Texas got the same thing, you know. Talks about it in 543 up to 549 that detained is an arrest. I've made a couple of videos how the cops went in there and told a cop watcher that detained is an arrest. Detained is an arrest. Now that's violation of due process. Go see a magistrate right then and there. I don't believe in magistrates, but I mean, that cop can't make legal determination. Oh, I had probable cause. No, you're making legal determination. We must go see the magistrate before I see the cage, and before you take my ID and all that and hold it against me, which is violation of my Fifth Amendment rights to incriminate myself. Bypass, 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 bypass. Constitution, state constitution, codes and statutes, it's a bypass.
And indeed, there
And they trespass upon you of your inalienable rights.
was a time when the federal bankruptcy judges, not real Article 3 judges, but we call them that, had enormous authority to enter into decisions of this kind. And in 1982, the Supreme Court actually said that was a problem. And Congress has had to restructure the federal bankruptcy process so that the orders are actually signed by district judges, by honest-to-goodness Article 3 judges, to make it official. We're still litigating the full contours of those limitations today, so it's not even settled fully today. So suffice it to say, this is a question of some importance, to which, as of this moment in time, we do not have a clear, crisp answer, and there is no prospect, I would say, no prospect at all, that you're going to get an answer in the near future.
They are leaving it open, and other judges are leaving it open for other judges to bypass the Constitution. State laws. It's a bypass, all right? So that way they can, under particular judges' belief, that they are allowed to intervene in your inalienable rights.
Are there any recent relevant examples of problems or confusion that might be caused by non-Article 3 courts?
Here's an example of the mess that we're still in trying to figure out what kinds of adjudicatory functions can be performed by executive officials.
Land taxes when you own the property, 1. Tickets, 2. Everything's done in civil law and not criminal, even though they claim a civil and criminal is one and the same in certain incidents.
Even executive officials who call themselves judges, or have to be performed by honest-to-goodness real Article 3 judges. The Supreme Court decided a case involving a newly created agency called the PTAB, the Patent Trial and Appeal Board. This was part of a statute, the America Invents Act, that was supposed to simplify and streamline the patent process.
And right here, y'all, they're going by civil law, but there is such things as common law civil law, right? Every man has a right to contract. Well, you still got the common law right to go in there and make your claims and stand in and all that with Article 3 judges. Not these wannabe judges.
The worry was that there had been a lot of really bad patents granted by an administrative agency, Patent and Trademark Office, that were out there stifling innovation. Now, if there's a bad patent out there, there has always long been legal methods for getting rid of those patents. You challenge them in court. or more precisely, you infringe the patent, wait for the person who holds the patent to sue you, and then claim that you can't get sued because their patent is invalid because it never should have issued in the first place. And then you will have an honest-to-goodness Article 3 court deciding the case, ultimately ruling on the validity of the patent. Everybody agrees that's fine. You can do that. The America Invents Act isn't satisfied with that. It created this Patent Trial and Appeal Board as an administrative agency.
We're going to stop there again. Right? The IRS has their own court. Patent has their own court. None of it's constitutional. Alright? Terrorist watch list thing. Their own courts. There's all these own courts that's not constitutionally there.
They're called patent judges, but they're not Article 3 judges. They're administrative officers. And what this body does is it hears complaints from people about supposedly lousy patents. It looks over the patents that have already been issued and that are out there and decides whether or not to cancel them. So you have an administrative body that's invalidating or canceling patents that have already been issued to someone. Can they do that? Well, the Oil States case presented a kind of odd challenge to that process. Went around what I think are the main issues. If you have a civil case in federal court, you normally get a jury. So they were claiming that by shifting this into the administrative process, they were being deprived of their right to a jury, and the Seventh Amendment to the Constitution guarantees in civil cases the right to a jury that you had in 1791. So by the time this case gets into the Supreme Court, there's already a fairly settled body of law suggesting this is a real long shot. They're probably not going to win. And they didn't. They lost. Here's the more basic problem with the Patent Trial and Appeal Board. It was alluded to in the Supreme Court decision, but not actually argued. What this body is doing is canceling people's patents. If you think patents are property, the kind of property that the Fifth Amendment is talking about when it says don't deprive people of life, liberty, or property without due process of law, then you have the question whether you can have an executive body, an executive agent, simply making your property disappear without going through the process of an actual honest-to-goodness trial in an Article 3 court. There is...
Again, property taxes. Your car, people, when the cops confiscate your car, they confiscated your car before due process. Property taxes, you guys know, they put liens on there, and it's the attorney and the county doing it without even so much the small courts, let alone big courts. Didn't think about it, y'all.
Probably not a comparable problem with what most of the executive officials who call themselves judges are doing, because most of what those people are doing is adjudicating benefits claims, Social Security benefits, veterans benefits, federal welfare benefits of various kinds, right? So this PTAB problem is a nice microcosm of the sorts of issues that are posed when we have executive officials not just deciding things, they can decide lots of things, but deciding things that actually dispose of people's life, liberty, or property. That does actually pose a serious risk of undermining the protections built into the process by Article 3. But, as of this moment in time, the case law does not appear to be very receptive to that kind of argument.
Thank you for listening to this episode.
Sit and think about it, y'all. You got to see several non-judges before you can get remedy and see a real judge. You got to go certain processes to be able to see a real judge. Now, tell me or tell me not. Is that a violation of your due process? Justice delayed. Justice delayed. Justice delayed until you see a real Article 3 judge. If in fact a real Article 3 judge even exists today. Think outside the box, people. What are they doing? We see these cop watchers and we see the compromising and all that kind of stuff with non-judges. How do these non-judges get so much power over you and tell you that you don't have a constitutional rights? How do they even can make that legal determination? I don't know, y'all. I'm just thinking outside the box. Diesel We the People News. Bye, y'all.